Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning, everyone. Thank you, Larry, and thank you all for joining us on the early morning. As Larry said, my name is Justin Winch. My practice involves employment law, estate litigation, and general commercial litigation. I've been practicing law for just over 5 years now, and I've been with DSF for almost a year. I've been asked to speak on the subject of employee bonuses this morning, specifically employee bonuses as they are needed to be paid during a notice period following a termination. This is certainly a somewhat dry topic, but it's an important one. Understanding employee bonuses and how they work post-termination can often be the difference between a quick resolution to a wrongful dismissal claim and a lengthy, protracted lawsuit. Now, as employers and HR professionals, I'm sure many of you are familiar with employment contracts. Often an employee will have a base salary. That salary could be anything. And on top of that salary, they may also be entitled to a bonus compensation or incentive compensation. As employers or HR professionals, you may have made the decision to terminate an employee. You've looked at their contract, and you see that they receive a base and a bonus compensation. You've worked out how long they've been at the company, and you've decided that a reasonable notice period would be, for instance, 6 months. Now, what would the pay include? Does it include simply the base salary, or do we have to make room for this incentive compensation? Well, if you came to me, the first thing I would do is ask, let's take a look at the contract. What does it say? Does it have any specifics in the section under incentive compensation? Does it have a timing mechanism, meaning a bonus would be paid at a specific date, or after certain obligations are met? Generally speaking, the law here is if the bonus would be payable before or during the notice period, then it would have to be included as part of the termination pay. But sometimes the courts don't always follow general rules. There was a case decided a few years ago in the Ontario Superior Court, and it was called Schumacher and TD Bank, Toronto Dominion Bank. That case dealt with a provision. It had a strongly worded employment contract, and it stated that recipients of bonus pay must be actively employed by the bank at the time the award is paid in order to be eligible to receive such compensation. Now, in that case, Mr. Schumacher, by virtue of being terminated by the bank, was no longer actively employed and therefore, under the contract, would not receive his bonus compensation. Well, Mr. Schumacher didn't like that, and he fought it in court. And Madam Justice Kitely in the Ontario Superior Court concluded that the employee's involuntary inability to comply with the condition of the contract ought not to be justification for the bank to decline the awarding of an integral part of their compensation. If that were the case, the employer would achieve a significant advantage by wrongfully terminating an employee because the severance package would not have to include any bonus. This was a case where, despite strongly worded contractual language, the clause was held ineffective because it would yield an unfair result. On the other hand, there have been cases which have upheld language which involves or requires employees to be working for a full 12 months for the full calendar year prior to a bonus being paid. And in that case, where the company has a history of following this policy, meaning if you only work for 8 months, you don't receive that bonus pay, and where such a clause has been properly and effectively communicated to employees, the courts have held that in those cases, bonus pay may not be applicable during the notice period. Now, what happens if the contract is silent when it comes to the bonuses and bonus pay? Often, generic employment contracts will simply have a base salary and entitle an employee to a bonus that is what we call discretionary. Employers will often argue that because this bonus is classified as discretionary, it allows them to pay no bonuses post-termination. Unfortunately, the case law says that that's not always the case. This will come as a surprise to many employers. Again, they will argue that they agreed to this contract, and in this contract, the bonus was defined as discretionary, and therefore they should not be compelled to pay it during the notice period. Again, cases have held that where the bonus forms a significant part of the employee's compensation and has been typically paid over a number of years, it will therefore become part of the employee's entitlement package during the notice period, notwithstanding its discretionary label. The thinking of the courts appears to be that the more often a bonus is paid, the less discretionary it becomes. A leading case on this topic is that of Reichsfan and Burns Fry Limited. In that case, an employee was earning a $60,000 base salary and typically received a bonus in the approximate range of $50,000 per year. The employer in that case only wanted to pay termination pay based on the $60,000. The court, in deciding what was an appropriate package for the dismissed employee, looked to the history of the employment and looked at the evidence that was submitted. They saw there was an employment contract which set out both base compensation and incentive pay. They also heard testimony from a manager of the company who testified that professionals there always received a bonus. They heard from the plaintiff who testified that he had received a bonus each and every year during his 11 years of service. The court concluded that the bonus was a major component of his compensation, and as a result, he was awarded a termination pay based on the $110,000 as opposed to the $60,000 that the employer had wished. So, even if a bonus is explicitly stated in an employment contract as discretionary, where an employee receives a bonus each and every year, and such a bonus can be said to form an integral part of their compensation package, it will become part of the remuneration that they would receive in any wrongful dismissal case. Finally, some courts have even taken this a step further. In the case of Hansen and Altus Energy Services, this is an Alberta case, but it has been applied in all provinces. The defendant employer argued that the plaintiff should not be entitled to damages for a discretionary bonus which they may have earned because it was their prerogative that year not to pay bonuses to any of their employees. It had been a damn year, and that was an across-the-board decision they had come up with. Fortunately, the employer's argument did not win that day. The court found that the plaintiff was entitled to damages for the bonus compensation. The court indicated that it was up to them to determine from the evidence the intention of the parties regarding the entitlement of a bonus. A bonus scheme that was historically an integral part of an employee's wage gives rise to the expectation on the part of the employee that a bonus would form part of a termination package. It doesn't matter what the future intent of the company was. The court looked at the past behavior and how the expectations have evolved of both the employer and the employee when it comes to bonuses. And in that case, on the basis of history, where the employee had received a bonus in almost each of the 23 years of his employment, it was found that he had a reasonable expectation of a bonus, and the court compensated him for same. When dealing with employees, it's important to consider this topic both at the beginning of employment and at the end. When drafting an employment contract, it should be carefully constructed so that any clause which limits bonus pay can stand up to legal scrutiny and to a fairness test that the courts will often impose. As well, such a clause must be reasonably communicated to an employee. For if an employee is not aware of any restrictions on these clauses, the courts may find that it is invalid. Finally, as I leave you, the key in all of these cases, just to sum up, is that employers need to consider when terminating employees and determining what a reasonable termination package would be, they must consider whether the bonus component is truly discretionary or whether it is formed an integral form of the employee's compensation, because a bonus payment cannot be both. The courts have been clear that we must look to the past to find out whether bonus compensation is truly discretionary. Thank you for listening to me this morning. It's a complicated topic, and if anybody has any questions on it, I'll be happy to speak with you following my colleagues' presentations, or feel free to take a card and we can discuss this matter further. Thank you.